Yes,
Guys,
you may
just to
proceed.
confirm, are you able to share the screen, the searches of both the sides?
Yes.
Okay, thank you.
And should I start?
Yes, please.
Greetings to the Honorable Bench. May it please the Honorable Court. Today, I, Ritu Karwa, appearing on behalf of the appellant, ABC Bank, in the present matter of ABC Bank versus XYZ
I'll
Private
have
Limited.
to stop you there. Ritu Karwa, is it? Your
Ye-
screen has frozen.
Oh, am I visible and audible properly right now?
Yes.
Okay,
Yes, please proceed.
much obliged. The council seeks permission to address to address collectively as honorable bench.
Yes, please.
The council has approached this honorable apex court under section 62 of the Insolvency and Bankruptcy Code, challenging the decision of NCLAT and submits that by virtue of the same, the court has full authority to pass any judgment or decree or order of justice, equity, and good conscience. For the sake of brevity, the council would be summing up the facts of the case in a few lines. The council seeks permission to proceed with the facts of the case.
Yes,
Please
please.
proceed.
Much obliged. ABC, a public sector scheduled bank, disbursed a loan of rupees 500 crore to XYZ Private Limited, which operated in the energy sector business. Uh, after a point of time, the XYZ Private Limited defaulted, and multiple restructuring requests were made from the XYZ Private Limited to the ABC Bank, and a series of notice requests were made from 2017 to 2022. Upon the default, the respondent's account was classified as NPA on 1st April 2014. On the 1st of Feb 2020, the ABC Bank agreed for an OTS agreement, but that was also failed by the XYZ Private Limited. Further, the COVID pandemic followed, and the insertion of Section 10A into the IBC happened. My client, ABC Bank, then filed a Section 7 application under the NCLT, listing the date of default as 1st May 2020. NCLT dismissed the application by the virtue of Section 10A, and the same was upheld by the NCLAT. Further, my client, ABC Bank, filed a fresh Section 7 petition on 1st Jan 2024, this time taking the date of default as original NPA date, that is the 1st of April 2014. The NCLT rejected the same, and the NCLAT also further upheld this decision. The council will be divided. The council would be dealing with four issues in the present matter. The council would I would be dealing with first and fourth issue, and my co-counsel would be dealing with the second and third issue. The council
All
will
right.
be divided. The council seeks permission to move forward with the submissions.
Please do.
Much obliged. The council will be dividing the submissions pertaining to the issue 1 into two sub-issues. First, the issue 1 talks about whether or not a second application under section 7 of the IBC is barred by the law.
Speaker,
What, Mr.
your voice is breaking. Your voice is not clear. I think you have an issue with your internet.
Just a minute, I'll fix it. Am I audible properly now?
Yes, now you're audible.
Apologies for the inconvenience.
When you are talking, as you are talking, suddenly it's cracking up. That's what's happening.
Okay. Apologies for the inconvenience. We'll try our
That's
best
okay.
not to.
It's okay. It's okay. Please proceed.
Much obliged. It is humbly submitted before the honorable court that the second application filed under section 7 of the IBC is not barred by res judicata, as the earlier application was dismissed solely on the grounds of technical grounds arising from the operation of section 10A and not a merit of the claim. The honorable bench, the council shall proceed to demonstrate that the foundational elements required for res judicata are conspicuously present in the present matter, and further, that a fresh cause of action has arisen independently through multiple statutory acknowledgements. Towards the first submission, Your Lordship, Your Honorable Bench, Section 11 of the CPC enunciates that no court shall try any suit or individual directly and substantially in
Your
issuing
voice
a
is
form of
again
suit.
cracking up, dear. Your voice is again cracking up.
Just a minute. I'll try to fix.
Why don't you do one thing? Court Master, can we stop the clock?
Yes, Your Lordship, we can.
So, Speaker 28, TGA
Yes.
28, why don't you, do you have any other alternate internet connection on which you can get onto?
Yes, we'll try. Just a moment.
Yes, so try that. Maybe it might be working for you.
Hello?
Yes.
Whenever you're ready.
Yes.
Okay, Court
Should
Master, we can restart the clock.
Yes, Your Lordship.
Apologies for the inconvenience. The council would move forward with the submissions of the case. So coming back, the section 11 of the CPC enunciates that no court shall try any suit or issue which was directly and substantially in issue in a form or suit, provided that such issue has been heard and finally decided between the same parties by a court of competent jurisdiction. The statutory requirement that the matter be heard and finally decided presupposes that the court must have afforded the parties an opportunity to advance their submissions and, after consideration of the same, should have rendered a decision on the merits. In the present matter, the first application filed by the financial creditor under Section 7 was dismissed by the NCLT and the NCLAT exclusively on the basis of the bar under Section 10A, a bar that is purely statutory in character. The authorities did not undertake any examination of the substantive merits of the financial claim or the existence of the default. The Council would like to draw your Honorable Bench's attention to the object and ambit of Section 10, which unequivocally talks about the suspension of the initiation of the CIRP process where the default has occurred
Do
during
you
the
have
10A period.
do you have any precedents on Section 10A?
Uh, yes, Your Honorable Bench. The legislative intent for the Section 10A has been squarely put forth in the Sushma Paranzape versus Rohan developers case, where it has been said that the Section 10A has been put into force and it does not contemplate any adjudication on the merits of the debt, liability, or the default.
Is it possible for your researcher to display that particular para?
Just a moment. We would this the same is we would display it later as I finish my first sub issue. Accordingly, a dismissal grounded in Section 10A cannot be construed as a final decision on the merits of the or for the purposes of the res judicata. Furthermore, the principle is also fortified by the decision in Prem Kishore and others versus Brahma Prakash and others, wherein it was observed that when a formal proceeding is dismissed on account of technical or procedural ground, the decision does not operate as res judicata in the subsequent proceeding. In the present case, the dismissal was blatantly non-meritorious, and the NCLT did not venture into any adjudicatory analysis of the substance of the claim. As such, the bar of the res judicata cannot be invoked for it applies only where there has been a final determination on the merits.
What is your jurisdiction?
Section 62 of the Insolvency and Bankruptcy Code.
Elaborate, please.
Section 62 talks about Section 62 talks about when the appeal goes to the Supreme Court when the same has been dismissed by the NCLAT.
Mm-hmm. And when we are talking about, okay, you proceed.
I have
Okay.
a
Follow-up?
follow-up, but it's a slightly so. In your opinion, do you think CPC is applicable to NCLT summary proceedings?
Um, so CPC, the principles of the CPC are not entirely applicable to the IBC proceedings, not
Can
squarely
you
applicable, but the proceedings are not applicable, but the principles of natural justice, good equity, and good conscience are squarely applicable. This has been set forth in the case of Vikas Dahiya versus Arrow Engineering, where it was squarely held by the NCLAT that the principle of the res judicata applies into IBC proceedings. If I may quote, so the decision of the NCLAT talked about the in the view of the principle laid down in the above judgments, the principle of res judicata, though a part of CPC, it would be applicable to the proceeding of this tribunal and IBC only to prevent the abuse of the process of law and give finality to the proceeding or the orders.
Is your researcher able to project the same on the screen?
For the same case,
Yes.
just a moment.
Researcher, when your speakers are arguing their case, as they are speaking, you should be projecting the relevant case law. This applies to both the teams. Is it readily available or it's going to take time?
We have the excerpt, but the order of the we are just trying to showcase the exact paragraph of the
Okay.
judgment.
Okay. Okay.
In the meantime, if your honorable bench uh, is okay, should I move forward with the submission of sub issue 2?
please
Yeah.
go ahead?
Much obliged. The sub-issue 2 talks about when a fresh cause of action has arisen through multiple acknowledgements. To further substantiate the argument, the council would like to prove how a fresh cause of action arises through multiple acknowledgements. It is humbly submitted before the Honorable Court that by virtue of Section 238A of the IBC, the provisions of the Limitation Act 1963 stand attracted to the applications under Section 7 and 9. Article 137 of the Limitation Act governs the proceedings of the IBC in this context and prescribes a limitation period of 3 years commencing from the date on which the right to apply accrues, that is the date of default. However, Section 18 of the Limitation Act provides that when a written acknowledgement of the liability is signed by the debtor prior to the
Section
expiry of the
19.
limitation,
That is section 19, not 18.
apologies, but
Please note it down for later. It is section 19.
much obliged. Uh, Signed by the debtor prior to the expiry of the limitation gives rise to a fresh period of limitation from the date of such acknowledgement. This position has also been authoritatively affirmed by Supreme Court in Dena Bank versus C. Shivkumar Reddy. If I may request to share the screen for the same,
Yes.
wherein it was held that each acknowledgement of debt serves to extend the limitation period by an additional of 3 years. Consequently, each valid acknowledgement constitutes a fresh cause of action which is unaffected by the principles of res judicata as mentioned in Bombay Gas Company Limited versus Jagannath Pandurang. If the council may interject regarding the section 18 of the Limitation Act, it is section 18 of the Limitation Act which states that the debtor can extend the period of limitation by giving a prior acknowledgement and not the section 19. Hence, in the present case, although the account was declared NPA on 1st April 2014, a series of OTS proposals spanning from 2017 to 2022 constituted unequivocal acknowledgements under Section 18 of the Limitation Act. These acknowledgements repeatedly extended the limitation period. Accordingly, the second application filed under Section 7 is well within the extended limitation and cannot attract the bar of the res judicata. If the honorable bench does not have any further questions, the council would seek permission to proceed with the issue 4. Much
I
obliged.
just have a couple of queries. One,
Yes, sir.
when you talk about restarting the period of limitation, is that a continuing cause of action, or the cause of action gets split every time an acknowledgement is made?
In the
Because you can
present,
only approach court for a particular cause of action. If you have a different cause of action, it's a different case altogether. So, in your opinion, is it a fresh cause of action or a continuing cause of action?
uh, so in the present case, multiple acknowledgements have been given for the same cause of action which has been arising. The section 18 of the Limitation Act also states that when a written acknowledgement of the same liability has been given before the expiry of the limitation, it gives rise to a fresh period of limitation, but the same cause of action. It
What is
is
the
a
limitation period for filing a Section 7 petition?
3 years
From
from the date of default.
what? So the date of default as per you is 1st of May 2020, correct?
It was taken into consideration during the first application, but accordingly, and as given in the clarification form as well, the NPA date is the date of default.
So can the date of default be changed?
It can be changed. It depends on the circumstances. The same shall be dealt with by my co-counsel in issue 2 and 3 extensively.
Then continue to issue 4.
Now, I also have one more question. When you talk about
Yes,
your
sir.
date of default, does it change or is it fixed? Or is that also your co-counsel will be handling that matter?
The date of default does change depending on the causes of action, and but but the original NPA date, which is when the account was classified as NPA, is our original date of default. The same has a lot to do with different intricacies, which needs to be taken into consideration,
No,
which is
just stop the clock, please.
Done, Your Lordship.
Yes, sorry. Please continue.
the date of regarding the date of default question. This it has a lot of intricacies which are extensive in nature, which needs to be explained, which is exactly why my co-counsel would be dealing exclusively with those two issues.
All right.
Much obliged.
Please proceed.
Much obliged. Moving forward to issue 4, which talks about whether a case can be admitted if the default has occurred and the application is within the limitation despite an error in the date of default. It is humbly submitted that where the occurrence of default is undisputed and the application is well within the limitation, the petition must be admitted despite an error in the date of default. This is because of the core essentials, that is, the debt and default, stand fully satisfied in the present case, leaving no discretion with the adjudicating authority to reject the application. Such errors are merely curable irregularities and can be rectified without the dismissal. Your, the honorable bench, the existence of debt and default mandates the admission of the application. In the present case, the appellant has filed Section 7 application seeking initiation of CIRP. Under the IBC, two essential ingredients need to be satisfied. First, the existence of a financial debt. Second, of default in the payment. Your lordships, this honorable court in M. Suresh Kumar Reddy versus Canara Bank has clearly held that the non-payment of even a part of debt when it becomes when it becomes due amounts to default. More importantly, the court clarified that once default is established, an order under Section 7 must follow, leaving virtually no discretion with the NCLT to refuse the admission. Applying this same logic to the present case, a term loan of rupees 500 crore was disbursed by the financial creditor. The corporate debtor defaulted on 1st of April 2014. Thereafter, repeated OTS proposals continued until 2022, clearly acknowledging the outstanding liability. Thus, both the essentials, debt and default, stand firmly established. Therefore, despite an error in the date of default, the application ought to be admitted. Further, the law distinguishes between the malified alterations which cannot be permitted and bona fide corrections which must be allowed when supported by the record. The Honorable Bench, this principle was reiterated by the NCLT in Canara Bank versus Wasabi Power Services Private Limited, which I request my researcher to please showcase on the screen. If I may draw the Honorable Bench's attention to the highlighted part, the tribunal held that the correction
Can you
of
maximize the screen?
yes, sure. Just a momentary pause. We are facing.
Okay, we can see.
Yes. Uh, if I would like to draw your honorable bench's attention to the highlighted parts where it has been clearly established that the tribunal held that the correction of an incorrect default date is permissible before final adjudication, provided it does not introduce a new cause of action and causes no prejudice to the corporate debtor. In the present matter, there is no new cause of action. There is only identification of the correct commencement point of the continuous and ongoing default. Therefore, the rectification of a bona fide error cannot be a ground to dismiss Section 7 petition, particularly when the debt and default are fully satisfied. Does
Counsel,
the
are you aware that there is a statute known as the Bankers Book Evidence Act? Are you aware of that act?
yeah, hello?
Is counsel aware of the statute which is titled as Bankers Book Evidence Act?
Yes, the council is aware about the same, not in great detail, but is aware.
Does counsel know that when a financial creditor under IBC files a Section 7 petition, they have to provide certified copies of their books to show that the default has mandatorily occurred? Otherwise, and that is the NPA date, which is the starting point, initial point. So when initially your petition was filed in 2020, and then subsequently it was amended, let's call it amendment, amended and filed with the starting date of the NPA, does that mean that the wrong certified copies of your default books have been provided to the court?
Thank you for the question, Your Lordship. To precisely answer the question, the Council would like to prove that there have been multiple cases where the NCLT and the NCLAT have held that merely the date of default, the irregularity in the date of default cannot render the application in its nullity. This is exactly the premise of our issue number 2, which would be...
Because the reason I'm asking, from the NPA point of view, is that on the date NPA was pronounced, IBC was not in existence. Correct?
Precisely.
When IBC came, it came in 2016. Even if we are to assume that there's a limitation period of 3 years from 2014, are you taking advantage of that limitation act in that sense to suddenly realize that we want to bring this under the purview of IBC, hence we don't want to go before any other tribunal? Is that why you had approached the NCLT the second time? Even though the NCLT had become a non-functioning court at that point of time after it rendered the Section 10A dismissal.
Thank you for your question, Your Lordship. To answer the question, the first NPA date was the 2014 date. Further, the 20 IBC came into
Hmm?
existence in 2016.
It took 2020
Multiple
to.
OTS. I'm sorry, pardon.
You are saying that the date is fluid, right? You're saying basically your argument is that the date is fluid, isn't it?
No, that is not the case. The council seeks to prove that the IBC when it came into 2016 is retrospective in nature, and the objective of the IBC is to maximize the value of the assets and give the corporate debtor a chance to resurrect their business, to keep it as a going concern in the present case, which is exactly why the
Then
OTS.
why did you first pick 2020 and then later revert to 2014?
The multiple OTS proposals were given by the corporate debtor, and one of them got accepted, but the XYZ private limited company did not fulfill the obligation to complete their payment, which got defaulted in the 2020, which is why
But
the date.
isn't that exactly what the NCLT warned against? This arbitrary shift. Isn't that what the NCLT warned against?
But the NCLT also talks about that when there's an existence of debt and default and multiple
Hmm.
opportunities have been given to the corporate debtor for the repayment of the debt, the same question cannot be merely dismissed on the ground of technical irregularity. The existence of debt, which is exactly why the corporate debtor was giving us multiple OTS proposals, an acknowledgement of to one of the tranches of the payment happened in 2020. The OTS settlement application, one of them got accepted in the year of 2020 and was defaulted
So
again by the
you
XYZ.
are treating the OTS as a fresh contract, is it?
No, precisely not. The OTS is just a mere acknowledgement on the side of the corporate debtor to fully and finally settle the debt. And when the opportunity was hence provided to the corporate debtor, they failed in completing the same, which is exact and precisely the objective of the issue 2 and 3 is exactly this, to address that what is the date of default and how it should be dealt in much more brief.
Okay.
Okay.
And all right, maybe we'll come back to you a little later. You can continue.
The council has completed the submissions for issue first and fourth. My co-counsel would take over for issue second and third.
All right.
Your Lordship, sorry to interrupt. Speaker one has taken 26 minutes, so she has
It's okay.
extended. Okay.
It's okay. It's with our permission that we were also asking questions, so it's okay.
Yes. All right, Your Lordships.
Yes, speaker two.
Just give me one moment.
Courtmaster, how much ever time is being extra allotted to the appellant, the same amount of time will be allotted to the to team number 18, is it? Yes, to team number 18.
All right, Your Lordships.
Um, Greetings to the honorable bench. As stated by my co-counsel earlier, my submissions would pertain to the two issues. Issue number 2, firstly, whether or not mentioning the date of default is mandatory in the application under IBC. Your Lordship, I would like to address the bench collectively as Your Honor, if that is okay.
Yes, please go ahead.
Much obliged, Your Honor. It is humbly submitted before the Honorable Apex Court that the requirement to mention the date of default is neither mandatory nor sacrosanct in an application under IBC, so long as the same can be determined from the evidence placed on the record. Before I make my submissions, it is respectfully brought to your Honor's attention that the relevance of this issue must be examined from the standpoint of whether the date of default is indeed essential, especially when in the present case the date of default has in fact been mentioned. The council will endeavor to demonstrate that the date of default is not of paramount significance in the application itself, and therefore in the present matter, the dispute regarding the appellant's alteration in the date of default ought not to carry any significant consequences. Your Honor, my submission under this issue would pertain to the two sub-issues. Firstly, that the date of default is not necessary if it can be determined from the record or the evidence of default. And secondly, the non-mention of date of default doesn't render the application defective. Going ahead with my first submission, Your Honors, the impugned procedural requirement that is mentioning the date of default arises from Part 4 of the Form 1 under IBC for an application under Section 7. Your Honors, Section 7 provides a substantive criteria for admission of the application, namely the existence of a default and completeness of the application. Your Honors, it is my humble submission that the date of default in the application is merely a procedural detail, and omitting it does not attract any fatal consequences. This honorable court, in the case of Innovative Industries versus ICICI Bank, has observed that an incomplete application refers to the absence of mandatory documents or a failure to satisfy the basic requirements of Section 7 and not to the omission of particular data fields. Your Honors, although Part 4 of Form 1 includes a space to mention the date of default, however, its omission is not fatal since the timelines under Section 7 are directory and not mandatory, as was held by this Honorable Court in the case of Surendra Trading Company versus Juggilal Kamlapat. Your Honor, in the present case, the appellant has mentioned the date of default. However, even assuming an omission, the date of default can be clearly determined from the date of NPA
So
classification.
you had mentioned that case law just a while ago, right? Can your researcher put it up?
Do you have that?
Yes, Your Lordship, just give me one moment.
While your researcher is putting that up,
As I said, as you are quoting case laws, researcher, please project it.
Your Honor, if it is okay, then can I move ahead with my arguments and the researcher will put it up
Okay.
subsequent.
Okay. But
Much
please make
obliged.
sure that as you are arguing, even team 18, as you are arguing, I want the case laws to be projected on the screen. I don't want to come back to it. I'm not going to sit and make note of what I want to read later. I want it as you are talking, your case law should be projected on the screen. Okay? Yes, please proceed.
Much obliged, Your Honors. Your Honors, moving
do
on
you
to the
have any judgments? Don't project it, but do you have any judgments which talk about date of default being directory in nature, not mandatory? That
in the case of as just cited by the council, in the case of Surendra Trading Company versus Juggilal Kamlapat,
but this was
the court,
pre-IBC.
sir, the case was in 2017.
Okay. What does it say?
So the court held that the timelines under Section 7 is directory and not mandatory,
Okay.
as was held by this court.
Is there any later
And
judgments which
uh,
substantiate this? Post
yes,
2020?
Your Lordship. In the case of Geocon Infra Private Limited versus Bridge Gopal Construction Private Limited, this was a case by NCLT, wherein the NCLT had admitted the date of default, had admitted the application wherein the date of default was not mentioned. So here I quote the NCLT. In the present matter, the date of default has not been specifically mentioned, neither in the demand notice nor in Part 4 of the application. Hence, we observe that non-mentioning of the date of default does not affect the merits of the present case. Your Honors, this case squarely clarifies the stance that date of default is merely a procedural compliance, and even if it is not mentioned in the application, which is a statutory form, it does not render the application defective, and that is precisely the second submission of my the second submission under this issue. Your Honors, it is my humble submission that what must guide the interpretation of Section 7 is the purpose and not the procedure. Its objective is Its objective is the timely initiation of CIRP upon the proof of default, not the rejection of claims on the technical procedural grounds. That is the reason why, Your Honors, accordingly, in the present case, the date of default is not sacrosanct or important under Section 7 of IBC. If there are any further questions, Your Honors, may I move on to...
I do. So you are saying that the acknowledgement reset your limitation. Is that the case?
Yes, Your Honor. So in the present
So
case,
if
what had happened...
acknowledgement, wait, if acknowledgement reset your limitation, why did you not use this acknowledgement in the first application to avoid Section 10A? Why did you use it in the second application?
Are you taking advantage of your own wrongdoing?
No, Your Honors, it is humbly submitted that the date that was mentioned in the first application was taken as 1st May 2020, which we as the financial creditors acknowledge as the one of the tranches of non-payment. And even in the case, and that is precisely what I was about to argue for the third issue. But since the question has been put up to the council, I would like to support my case by citing the case of Pradeep Madhukar More versus Central Bank of India, which this was a case by
Researcher,
NCLAT.
please put it up.
Is your researcher facing any issue in projecting? Is that the reason, or what is it?
Yeah, just...
Yes, please proceed.
Yes, Your Honors. So, in this case, the court had held that restructuring agreement is an authoritative source for establishing default, since each such acknowledgement revives the limitation period as the OTS and the restructuring demonstrate a continuing cause of action, and thus modifies the date from which default must be computed for the purpose of an IBC application.
Counsel, I still feel that you are taking an advantage of your own wrongdoing. Means first you commit an error, then you find out that it should not have been done, and then you go under the correct course. That is not permissible under law and equity.
And also explain why should the court treat this NPA date as a default when there was a restructuring problem. OTS was granted. OTS installments were separate. Why is the OTS default not the operative default date? Explain us that.
So, Your Honor, in many cases, even in the case of Babulal Vardarji Gurjar, the Honorable Supreme Court in this case had held that the date on which the loan account is classified as NPA should ordinarily be considered as the date of default. So here we substantiate the fact that in this case the NPA should be taken as the date of default, and this is not because we are doing it under bad faith, or just because our application in the first instance got rejected, that's why we changed the default. No, the first application, the date was taken to merely to acknowledge that since we had given the sanction to the corporate debtor an opportunity to pay, but they defaulted the same. And taking the case of Pradeep Madhukar, cited by the council, the court clearly says that a restructuring agreement gives rise to a fresh cause of action, and that fresh cause of action must be considered as the date from which the default must be computed. However, because of a mere technical ground, the first application was rejected, as was argued by my co-counsel in the first issue, because of a technical bar under Section 10A, which is not justified. And also, to further add to this point, even the court's dismissal of the first application under Section 10A, it was not related to the COVID-19 pandemic. And the NCLAT in the case of Puneet Bhatia versus ACREC Limited held that there must exist a clear and a direct link between the alleged date of default and the impact of the COVID-19 pandemic. But here in this case, the default had occurred primarily in 2014, which is not related to the pandemic period. And the reason why 2020 date was taken is because as to acknowledge the fresh cause of action, and that's why in good faith and not abusing the process of law, the date was taken. However, we do not deny the fact that NPA is not the date. We do not deny the fact that NPA is not the date of default. We in fact clarify that NPA is the operative date of default, which was right from 2014 to 2022. The period shows that the corporate debtor was in a continuous state of default.
So,
So the,
Please
so
ask.
when you are saying that the corporate debtor was continuous default, right?
yes,
Why did you wait for COVID? Why not immediately go under immediately in 2014 only? Why didn't you prefer an application then? I understand that there are a lot of communications that the corporate debtor has done with you guys, and that your legal manager, your bank officer has suggested that, okay, let us explore other avenues of settlement. But as an advocate, is it not your responsibility to inform the bank manager that the minute a default occurs, regardless of whatever communication is happening, we need to approach the courts on a war footing?
Your Honor, if we go by the facts of the case, the
I've
company
I've read the facts, I've understood that. I'm
yes.
putting a very specific question to you.
Hmm.
Why did the bank manager instruct you, the advocate, to wait 6 years? Let any communication happen. It's not of our concern. The communication only shows that the company is buying time. It is not having any propensity to discharge its outstanding dues. It does not show any inclination. In fact, you yourself, your co-counsel also has pointed out that it was only the Section 10A dismissal which prompted you guys to revert the clock and go back to the original NPA date. So, as an advocate representing the bank, was it not bound upon you to suggest that we should immediately approach the court in 2014 itself?
Your
Let the
Honor,
communication happen sideways. But court proceedings should start now.
Your Honor, under such a factual circumstances, we knew that we could have approached the court, but we were expecting that they would repay the amount, because the reason why they had sent so many letters, we knew that we had some kind of a confidence or faith in
When
them
did
that
the bank first approach you as to take up this matter?
uh, sorry, I
When did
didn't
the
get.
bank first approach you to take up this matter?
Sir, the bank approached us in the year 2016, right after the IBC had come into existence.
But as per them, 2014 is the date of default. So, 2016, the bank had approached you.
Limitation.
Limitation is there. Uh,
It's okay. So
but will IBC due to
please go ahead. We just wanted to understand what your stand as an advocate would have been at that point of time. What kind of an advice you would have provided? Why you asked them to wait for so long? We just want to know your thoughts.
Your Honor, that's what I was just to further clarify, because there was so much communication between both the parties. We
Hmm.
honestly were under the belief that the corporate debtor would in fact make the payment, because there was a constant kind of acknowledgement of the debt, and even the assurance given by the corporate debtor also by requesting OTS. So we were
So you
we were
waited
under.
till 2020 for the COVID and then only decided, oh, this is
Sir,
the right time.
So actually, we had in fact given them a sanction also in 2020, but later on they defaulted. So we then had to file the first application.
Please, do you have any other points?
Your Honor, uh,
Didn't answer. It's okay.
yes, Your Honor. Under my second submission of for the third issue, uh, the first submission clearly clarifies that the first application, the date was taken merely to acknowledge the restructuring agreement as the fresh cause of action, and the second submission pertains to the fact that NPA date should be taken because it is the operative date of default and it is formally crystallized, and even the RBI prudential norms acknowledge this particular stance, and that is the reason why the NPA date has been taken in the second application. And it was, again, to reiterate my point, it was not to abuse the process of law, it was not to merely get the application admitted, but
So,
merely
counsel,
to.
let me cut you short. Let me now, since time over card has also been put, to sum it up. Is it your case that it's the same debt? And point number two, for the same corporate debtor, can you have either date 2014 or 2020, depending on the bank's convenience? Is that your case? Please
No, Your
answer.
Honor. No, Your Honor. No, Your Honor. The date of default is not according to the convenience of the financial creditor, because under the statutory framework, the NPA was classified as according to the RBI norms, and that is the reason why NPA has been taken, and that is not according to the whims and fancies of the appellant. And I'm sorry, what was your first question?
Is it the same debt?
Your Honor, it is the same debt. However,
How come?
this does
How
not
come? Interest
attract
component
the.
will not add.
Sorry.
How come it's the same debt? There is a component of interest that you're not taking into consideration.
I'm sorry, I didn't quite
You
get
know
you.
what? When a bank gives you a loan, there is an
Correct.
interest component
Yes, yes.
which changes. So how come it is the same debt? You're only talking about the principal amount. You're not dealing with the interest.
Yes, yes. So the primary principal amount remains the same. However, the interest that is
It's
added
a
on to
6 years
it.
ka difference. The interest over 6 years makes a lot of difference.
Yes, yes. Correct. Correct.
So
I correct
that
myself.
is exactly from where I was coming. My previous questions also, if you recall, it's all coming from this component. This interest component varies heavily from date of default, which you yourself say is a procedural requirement, to the Section 10A dismissal, which is the 2020 debt. So it's not the same debt now.
Correct. I rectify my stance, Your Honor. Thank you for correcting me. If there are no further questions, uh, may I proceed on to my prayer?
Yes, please proceed.
Much obliged, Your Honor. The appellant most humbly and respectfully prays before this Honorable Apex Court that it may be pleased to find in their favor and to uphold the civil appeal preferred by the appellant and quash the orders of NCLT and NCLAT. And secondly, hold the second application under Section 7 as not barred, and or pass any other order which the Honorable Bench may deem fit in the ends of justice, equity, and good conscience. Much obliged. It was an honor arguing before the bench. Thank you.
Thank you.
Thank you. Thank you, both of you. And thank you, your researchers also. I don't see her screen. I mean, I don't see her on the camera, but okay.
Yeah. Thank you.
All right.
Let the respondents start.
Respondents can start.
May it
Codemaster,
please, Your Honor.
sorry. Whatever were the extra minutes, please add on to the respondents also.
All right, Your Lordship. Speaker 1 has taken 27 minutes and Speaker 2 has taken 20 minutes.
All
No
right.
worries. No worries.
All right. Over to the respondents.
Respondent speaker once you can commence.
May it please the Honorable Bench. We are the counsels humbly appearing on behalf of the respondent XYZ Private Limited before this Honorable Court. The counsel seeks permission to address the court as the Honorable Bench. The
Yes,
counsel
please.
also
Please go
seeks
ahead.
permission. Much obliged, Honorable Bench. The counsel also seeks permission to screen share the compendium.
Please do.
Much obliged. With the Honorable Bench's permission, I wish to briefly outline the issues that we will be addressing. I shall be advancing with the submissions on the issue 1 and 2, and my co-counsel shall be subsequently addressing the remaining issues, that is issue number 3 and issue number 4. The council also respectfully submits that 15 minutes have been reserved for each council submissions, and we shall endeavor to remain within the allotted time.
All right.
With the kind permission of the honorable bench, the council now shall proceed with establishing the facts of the case.
All right. We have gone through we have heard the facts.
The facts are done. You can go ahead with your argument.
Start the issues immediately.
Much obliged, Your Lordship. We shall now begin with the submissions. May it please the court, the first issue that we are putting forth is whether a Section 7 application under IBC is barred by law. So the respondents humbly submit that utmost clarity, firmness, and the second Section 7 application that has been filed by is actually legally barred and procedurally impermissible and even constitutionally offensive, incorrect due to the presence of res judicata principle, that too which exhibits in the principle of finality in judicial proceedings. The appellant seeks to re-agitate what has already been decided by the Honorable Court. The Honorable Bench, this is a very abusive process that the court is designed to actually prevent from happening.
Speaker 1, but wasn't the first dismissal not on merits? So then how can you say that it has finally decided?
But Honorable Bench, the fact that it was due to a statutory bar which was imposed on them.
But let that be. They have taken advantage of whatever sunset provision was provided for a short period of time. Let that be. But isn't this not a final determination?
Your Lordship,
this is not a final determination in our opinion.
Your Lordship, we are not denying from the fact that there exhibits debt and we are mostly willing to pay it back, but for the sheer fact that such a petition is not maintainable.
Please go ahead.
Do you have any Supreme Court judgment to that effect?
Yes, Your Honor. I shall be further going on to it.
Okay.
The appellant's argument, much obliged, Your Lordship. The appellant's arguments also earlier stated that the earlier dismissal was not triggering the principle of res judicata. To this, I would like to cite the case of EBIC Singapore Pte Limited versus Committee of Creditors of Educom Solutions Limited 2021. That is categorically held.
Can you just increase the screen size? It's very small. We can't see. Thanks. All right.
In this case, it has been categorically held that res judicata fully applies to IBC proceedings, and that a summary adjudication under such a court through SWIFT still creates the binding finality between the parties, where the cause of action is the same, the parties is the same, and this issue remains the same. The court explicitly warns against the re-litigation of identical issues or splitting of cause of action. That is exactly what the appellant is attempting to do here. Honorable Bench, I would also like to cite the case of Indian Bank versus K.R. Tirumurunan, wherein the principle was reinforced that by holding a second insolvency proceeding, even if under a different section, if not maintainable once the petition has been filed and adjudicated, it cannot be brought in for the second time. This is simply because of the sheer fact that the court does not permit multiplicity of proceedings, and on the same underlying default, it can never take place. The integrity of the insolvency resolution depends on the certainty and not on perpetual litigation, that until the desired result comes, they can go on and on as per their whims and fancies. Also, the attempt of the appellant has been made to downplay the earlier rejection as technical, but jurisprudence does not support such an escape route. Res judicata applies only when there are issues and that are decided on merits, but it also extends to all matters which are directly or substantially in issue, or in which...
Counsel, how can res judicata be applicable when the debt was never examined, the default was never examined, your documents were not examined, acknowledgements were not looked into, then the question of limitation, and or even the NPA date? So how can you say that there is res judicata?
You as the counsel for the company knew very well that the company has made payments up till XYZ date, and from XYZ date there is default by the company. How can you now turn around and not have all these what my fellow member on the bench asked, how can they not be, I mean, these criteria not be satisfied?
And how can you say that there is res judicata?
Much obliged, Honorable Bench. The sheer fact that we are not denying or undermining the fact that there exists debt or default on our part, but we are upholding the sheer fact that this application stands barred, as they could have easily resorted to an appeal or other forms of remedies, but this particular
Appeal
second
against what?
application,
Appeal against what?
they could have taken the same matter over the appellate court, or even filed the special leave petition on that very particular matter, instead of taking it on a second level, like appearing it, applying it for the second time.
How many times do you think they can, file this section 7? एक बार नहीं चला, दूसरा बार नहीं चला, तीसरा बार.
Exactly.
How many?
Exactly.
Yeah,
Your
please
Lordship.
proceed.
Yes, much obliged, Honorable Bench. The sheer fact that since once their application had been dismissed by NCLT, they could have taken up that particular matter, and the court has always promoted making amends or making rectifications on that very particular application. But instead of doing that, they have filed it on a particular different date, and that too on over the uh, appellate tribunal, the same very matter and the same cause of action.
Okay, please proceed.
Much obliged, Honorable Bench. So, to this, I would also like to cite.
Counsel, just give me a minute. Courtmaster, can you stop the clock? Can you excuse us for a minute?
Yes, Your Lordship, certainly.
Yes, please continue.
So, hmm.
Much obliged, Your Lordship. Your Lordship, just now the fact that I mentioned that about the amends and the appeals that the appellant could have done, to this I would like to cite the case of Dena Bank, wherein the court had
Hmm?
uplifted the same. Yes, Your Lordship.
No, we didn't say anything.
So I would like to cite the case of Dena Bank, wherein the court had upheld this very same aspect, that in such that the multiplicity of proceedings could be avoided, and such that the amends are made to that very particular petition or appeals before the Supreme Court are made in particular order. Also, Your Lordship, to this I would like to mention the principle of Henderson, which is also adapted by the Indian courts and falls under the UK jurisprudence, which bars precisely this kind of repeated litigation, where a party having a failed being having failed once in a litigation or a particular petition attempts to reframe it or repackage it or redate it in such a manner to claim or secure a very different sort of outcome. Honorable bench, such kind of a conduct, if permitted, it will floodgate the endless applications of the creditors, such as for the revised amounts, amended grounds until one is actually admitted. This would destroy the time bound purpose of IBC and actually turn the code into a weapon of harassment. Also, to this, I would like to mention that the appellant is also attempting
So,
exactly.
so does Section 10A forever wipe out the debt then?
Not at all, Your Lordship. It had clearly mentioned from the month of May, from 26/5/2020, from then to 6 months, and until mentioned for the period of 1 year, those period, the defaults that arise had to be shed off and nothing else. So we are not at all denying on the fact that there remains default in our part. We are more than willing to repay it back. But we are not suggesting the maintainability of such a petition.
Then how does res judicata apply on an issue that revives after the bar is lifted?
Res judicata, Your Lordship, if you could repeat it.
I was saying if you're saying that Section 10A doesn't wipe out your debt, then does res judicata apply on an issue that revives after the bar has been lifted?
Not at all. Not under this petition, but for the previous one. So if that continues, there is no question of res judicata existing.
Okay, please proceed.
Much obliged, Your Lordship. So herein, I would like to mention that the appellants are attempting exactly what NCLAT had warned us against, that is manufacturing a fresh default to date a recurrent claim that has already been rejected. This is not diligence, it is litigation engineering. The IBC also does not allow a default to be dressed up differently so that it may be forced to be thought to be accepted by the judicial threshold for the second time around. Honorable bench, I would also humbly submit that the second application under Section 7 is not only barred by res judicata, not only prohibited by the issue of estoppel, but it is also a direct abuse of the court, undermining the sanctity and the finality and actually inviting endless cycles of re-litigation. This is a statutory bar under 10A that has been imposed, which we totally accept. But the respondent therefore prays that this court actually upholds the principle in such a manner that such a petition is not accepted. And further, we can go on with the first petition that has been filed because we are more than willing to pay the debt. If your honorable bench permits, I shall move on to the second issue.
Please
Yes,
proceed.
please.
Much obliged, Your Lordship. So the second issue discusses whether mentioning of the current date of default is mandatory under IBC. The respondent humbly submits that with utmost emphasis that the requirement to clearly and accurately state the date of default under Section 7 of IBC, as mentioned by the Council of Appellant side, is not a mere formality and not a mandatory or just a significant, not that very significant thing, but it is a foundational jurisdictional requirement without which the adjudicating authority cannot even begin the inquiry. The date of default is the anchor from which limitations flow and from which Section 10A applicability has been determined, and from which the very maintainability of the petition is actually tested. The financial creditor cannot trivialize such a requirement as a curable defect as mentioned by them when it lies at the heart of the statutory mechanism. It was the financial creditor itself that had earlier asserted before the NCLT that the date of default occurred on 1st May 2020. And on that very basis, it's the petition that has been rightly rejected under Section 10A. Now, in desperate bid to evade the statutory bar, the creditor shamelessly attempts to rewrite the history and put it backward in 2014 year, when the 10A had clearly not existed. This is not correction. This is a sheer act of manipulation, and this is not a clarification as well. This is reconstruction. This goes to the
So then,
root of the
counsel, is there any principle under the IBC that prevents a creditor from correcting an erroneous date under the underlying default?
Yes, Your Honor, there are provisions for which they can make amends as per Section 7, and even the Form 1 and Rule 4, which also mentions that there is a provision of making amends to it.
Even when the default remains the same and it's the same transaction.
Right.
All right. Please proceed.
Much obliged, Your Lordship. The Supreme Court has also held that the limitation clock actually begins on the date of the default, and it can never be modified, reframed, or conveniently altered in order to cure a defect or to escape a statutory provision. If they would have to do it for 2014, they would have done it way back. But since they have done it for 2020, that is how it should go. Also, the appellant's attempt to shift the date of default is creating a mode of assault on the statutory framework, and if permitted would plunge insolvency jurisprudence into chaos by allowing the creditors to manufacture dates of suit as to their desired outcome. The code was enacted to let provisions of resolution mechanism, and not as a recovery tool where the creditors are free to remodel facts. Once the first is rejected, they come up with the second. To this, I would like to reaffirm by citing the case of K. Shashidhar versus Indian Overseas Bank, wherein the Supreme Court had stressed that commercial
Can you
disputes must
increase?
have.
Can you increase the screen so I can?
Yes, please. Yes.
Sorry for the inconvenience, Your Lordship. To this, I would like to add that the Supreme Court had stressed on the fact that commercial disputes must have finality and cannot be litigated endlessly after adjudication. The creditor is attempting exactly what the Supreme Court had warned us against, that is, relitigation, and that to the same default by repackaging the facts. Further, I would
But
like
the
to bring.
Supreme Court has also come out. There are so many case laws like Babulal and Lakshmipad Surana, which holds that the NPA date is only evidentiary and not determinative, right?
Absolutely, Your Lordship.
Then how are you saying that your case law is supporting your argument?
But the fact that the date of default occurring, such a mentioning is not a sheer mentioning, it is a jurisdictional fact which actually leads to the entire pathway of the inquiry of the entire matter. So, until and unless that is put on correctly by the appellant side, most importantly, the matter cannot go forth.
All right, please proceed.
Much obliged, Your Lordship. To this, I would like to state that furthermore, I would like to put the light on Section 18 of the Limitation Act, which offers no rescue to the creditor as they expected it to. The OTS proposals are inherently conditional, and the law is unequivocal that only a clear, conditional, and unqualified acknowledgement of liability can extend limitation. A settlement often made to negotiate a reduced amount cannot be twisted into an acknowledgement that too subsisting a default regarding pertaining to that. Treating OTS letters as acknowledgements would subvert legislative intent and artificially prolong a limitation period that was meant to be strictly construed. But even if we consider that, they are not even considering it in the right way that they should be. I would like to conclude by stating that the honorable bench, the existence of proof of the date of default is not optional. It is entirely mandatory, and the fact confers to the jurisdiction upon NCLT. Without a precise and proven date, the NCLT cannot determine the limitation, cannot assess the applicability of Section 10A even if it is on our benefit, and cannot initiate the insolvency process at all. So the ABC Bank's failure to consistently plead and prove to the essential jurisdictional fact is fatal to the maintainability of such a petition. to this, I would like my co-counsel to take over to the other issues.
Please do.
Much obliged, Your Lordship.
Good evening, Honorable Bench. Speaker 2 will be dealing with issue 3 and 4. And if the Honorable Bench permits, then I would like to begin with issue 3.
All
Yes,
right.
please.
Much obliged, Honorable Bench. So, issue 3 states whether or not the date of default changes based on facts and circumstances, or is it to be taken as the date of NPA in all bank matters? Honorable Bench, the respondent respectfully submits that the date of default is foundational and immutable fact under the Insolvency and Bankruptcy Code, and it cannot be altered, shifted, or reconstructed by the financial creditor to suit its convenience. The law draws a clear and conscious definition of default and NPA, where default is the cause while NPA is the consequence. The respondent, which is the XYZ Private Limited, submits that the NCLAT was entirely correct in dismissing the second application. The financial creditor here is attempting to manipulate foundational facts to escape a statutory bar. The law does not permit the creditor to treat the date of default like a dial they can adjust to suit their convenience. The counsel would also further talk about the critical fact in the case of the bank's contradictory pleading, where the bank, with full knowledge, solemnly declared the date of default to be 1st May 2020, which was the cancellation of the OTS. This was the bank's chosen, specific and definitive start date for the cause of action. In the second filing, after the first case was dismissed under Section 10A bar, which is a statutory blackout period, the bank suddenly filed a second petition, completely substituted the date with 1st April 2014. The bank cannot logically argue that a default occurred in 2020 and simultaneously argue that the default occurred 6 years earlier in 2014. This is a fatal contradiction in foundational facts. Further, the council would like to refer to the case of Lakshmipad Surana versus Union Bank of India, it's a 2021 one case, where, as established by the Supreme Court, the NPA date may only be used as an evidentiary convenience, which means that specific default date is not known. However, here the bank knew as well as pleaded a specific date of default, that is 1st May 2020 in the first application. They cannot now retreat to the NPA date simply because their first choice proved inconvenient for them. The corporate debtor relies on the integrity of the creditor's initial pleadings. The bank's shifting facts causes irretrievable prejudice because the debtor is forced to defend against two distinctive and mutually exclusive causes of action. This uncertainty violates the fundamental principle of fair procedure. Further, the council would argue that the dismissal of the first application by both the NCLT and the NCLAT, even if based on Section 10A bar, was a final determination on the maintainability of that specific cause of action as pleaded. The second application is based on the exact same date, same parties, and the set of loan documents. The bank should not be given an infinite license to refile until they find a combination of dates that legally bypass every statutory hurdle. Therefore, the respondent respectfully urges this honorable court to uphold the NCLAT's decision, where the bank cannot rewrite the cause of action and their attempt to use NPA date to escape statutory bars, which is legally unsustainable. If the honorable bench is satisfied with the arguments, the council would like to proceed to issue 4. Much obliged, honorable bench. Issue 4 states whether or not a case can be admitted if the default has occurred and the application is within the limitation despite an error in the date of default. The council respectfully submits that the NCLAT's decision must be upheld because the appellant bank's second petition is founded upon a fundamental defect, which is manipulated and legally inconsistent date of default. The bank's attempt to substitute its initial carefully chosen date is not a minor correction. It is an effort to rewrite the facts of the case solely to escape a statutory and judicial bar. Further, the council would like to contend that the date of default is sacrosanct under the Insolvency and Bankruptcy Code. It is not a procedural formality to be changed at the financial creditor's convenience. It is a jurisdictional cornerstone of Section 7 application. Now, the date...
Counsel.
Yes, Honorable Bench.
So are you saying that the bank chose the 2020 date specifically to take advantage of Section 10A provision? What?
Honorable bench, Section 10A provision would be an advantage to the corporate debtors part. The bank,
I'm sorry. Yes, a bank when it first filed,
yes, Honorable bench.
that time Section 10A was they used it, and for whatever reason the NCLT denied the relief. Then the bank decided to go back 6 years, rewrite the clock, and then came out with this NPA date when your client became a his loan became a non-performing asset, right?
Yes, Honorable bench.
So does that mean that somewhere there is some sort of a collusion between your client and the bank?
Honorable bench, my client, which is the XYZ company here,
Because it seems like, I mean, there is a doubt which is coming in my mind. I don't
Honorable
know what.
bench, the respondent had been repeatedly approaching the bank for OTS proposals from 2017 to 2022.
Correct.
When
That's correct.
it Yes, Honorable bench, it
What is
demonstrates
the
follow.
I mean, what is the position today? Is your client solvent? Is it still under water, or what is it?
Honorable bench, even after the 2020 OTS sanction was dismissed due to the COVID-19 period, and since our company, my client, could not pay back the OTS, even in 2022, the bank further applied to sanction an OTS. That very clearly shows that the company here has all its
Your
means.
client.
My client has all its means of repaying the entire amount at a one-time settlement. Therefore, the respondent's viable opportunity to resolve the financial difficulties at the time when it was still in position has itself made to be a substantial payment, where the bank exercised timely commercial prudence and they sanctioned the OTS, which was not seen by the bank. The bank had all the acknowledgements of the liability from the company, but there was no acknowledgement from the bank side. Even when during 2020, my client had provided the same OTS sanction letter, the bank came up and stated that fine, you can go ahead with the OTS, but our company, my client, could not repay the loan because of a technical problem due to the COVID-19 issue. Even
So you're
after,
saying that there was no collusion between your client and the bank?
Honorable bench, there was no collusion between my client and the bank because my client has duly acknowledged its liability. It was the
Maybe it is
bank's
just
default
a
and error where the bank did not acknowledge our acknowledgements.
question.
Okay, please proceed. We'll ask later.
Much obliged, Honorable bench. The council would further argue, based on the determination of the statutory immunity, where the date determines the applicability of Section 10, which prohibited filing during COVID-19 pandemic. As this Honorable Court emphasized in the Swiss Ribbons Private Limited versus Union of India case, the IBC demands strict procedural compliance. The NCLAT has repeatedly held that debt and date of default are mandatory as well as they are sacrosanct particulars, which is an incorrect or inconsistent date of default vitiates the entire computation of limitations. Further, the council would like to contend that the bank's action demonstrates a clear attempt at manipulation which causes irretrievable prejudice to the corporate debtor.
But council,
Yes, Honorable Bench.
Section 7 says that only the existence of a debt or default for admission is required. Okay. Why should the correction of date, which actually, if correction of date does not change the fact that there was a debt or the default in itself, why should the change of date defeat the petition? You tell me that.
Honorable Bench, the date over here does not defeat the petition. The bank had ample time to amend their first application, which was already dismissed by the NCLAT. Now, since the bank has not amended and filed a fresh petition just by changing the date, the entire matter or the entire resolution process comes collapsing just because of that one date change. Uh,
How
the
can a typo error? How can a typo error convert a valid claim into a forever barred debt? Sorry, forever barred claim, even when
honorable
there is default. And
honorable bench,
it is within limitation. It is within limitation. There is a default, but only because of a typo, you're saying it should be a forever barred claim, is it?
honorable bench, corrections are permissible only when the mistake is clerical. The correction does not alter the cause of action. Further, it does not defeat the statutory bar, which the bank in a manipulative way changes the date, and it does not introduce a contradictory foundational fact. Again, the date. Here, the bank is not correcting a mistake, Honorable Bench. It is replacing one factual foundation, that is 2020 to 2014, which is solely to escape the Section 10 bar that was provided a temporary resolution to the corporate debtor.
But don't you think so that you are having continuous conversations with the bank? You're having your own documents, your bank statements, your acknowledgements. All this is coming from 2014. Then doesn't a prejudice arise?
Honorable Bench, my client does not deny the fact that we are not able to pay or we do not want to pay. My client is ready to pay, even because this entire matter arises from 2014 to 2022 through all our acknowledgements, through all our documents, through all the OTS sanctions that were pleaded by my client. Here, it is the bank who erred on providing any kind of acknowledgement to all these kinds of documents. Therefore, I would request, or I would state that it is the bank's fault here for not entirely acknowledging all these documents. It is the company who deliberately had all the communications from the bank, but there was no reverse communications from the bank itself.
Okay. Well answered.
Your client had the documents, not the company.
I'm sorry, Honorable Bench, my client.
Okay. Please proceed.
You are representing your client, the company here,
Yes, Honorable.
not a third party.
Yes, Honorable Bench. Much obliged. The council would further contend on another argument before proceeding with the prayer.
Yes,
That
please.
is, the council uh, would contend that the core purpose of the date change was to circumvent the statutory protection given to the debtors under Section 10A. Now, here again, first filing, the date was 1st May 2020, fell squarely within the Section 10A blackout period, hence the dismissal. The date 1st April 2014, that was filed under the second filing, is an attempt to push the default before the blackout began. The bank is arguing that while their first petition was correctly dismissed under a statutory bar, they should be allowed to simply rewind the clock 6 years back to make a claim retroactively maintainable. Therefore, the council pleads that since the second application is founded on an inconsistent date, the bank has failed to meet the mandatory requirement of stating a sacrosanct date of default. We respectfully urge the Honorable Court to dismiss the appeal and affirm the NCLAT's finding that the petition is rightly rejected. If the Honorable Bench is satisfied with the arguments, then the council would proceed with the prayer.
Please do.
Much obliged.
What is the prayer?
Wherefore, in light of the facts stated, issues raised, arguments advanced, and authority cited, the counsels for the respondent humbly pray before the Honorable Court that it may uphold the impugned judgments dated 2024 passed by the Honorable NCLT, hold and declare that the second application filed under Section 7 of IBC by the petitioner is barred by the principles of res judicata and amounts to gross abuse of the process. Declare that in view of Section 10A of IBC, no application for initiation of CIRP can be filed for defaults. Hold and declare that the date of default cannot be unilaterally altered by the financial creditor to suit its convenience. Clarify that the mandatory requirement of specifying a single consistent date of default is central to maintaining the certainty and sanctity of the insolvency proceedings. Award costs to the respondent for being compelled to contest repeat and baseless proceedings, and or may pass any other order that this honorable court may deem fit in the light of justice, equity, and good conscience for this act of kindness. The respondent shall be duty bound as ever pray. Much
Thank you.
obliged, honorable bench. It was a pleasure arguing before the honorable bench.
Thank you.
Likewise, it was a pleasure listening to you. Yes, time for rebuttal.
The counsel for the appellants would like to rebut the submissions of the respondents based on 4 to 5 contentions which they have raised in their arguments. So, firstly, the respondents have clearly admitted and invariably said that the company XYZ Private Limited is solvent and has the ability to pay the debt. The respondent itself has landed itself into troubled waters, because if they have the ability to pay as to what the debt is owed by them to the bank, then why do they need the protection of the TENE of the IBC, and why do they seek it so desperately? The objective of the TENE is itself defeated there itself, and and it cannot be decided on the merits. Further, the counsel for the respondents also said that the OTS proposals which they sent to the bank were not an acknowledgement of the debt, but the OTS proposals talk about one-time settlement. Proposals invariably start with the fact that you owe a debt to the financial creditor, and that is exactly why which they need, which they are acknowledging. So the counsel of the respondents are contradicting themselves a lot through the submissions. Further, the counsel for the respondent talks about that the remedies which the applicants should have sought would be that we should have amended the application or something like that, or something based on those lines, or gone for a SLP or something like that. But in the present case, the NCLT and when we file another another application before the NCLT, that is exactly what they're rebutting, that we should not have filed. So I would urge the council of respondents to prove that how do we go about this, and if they have the ability to repay, then why are they circumventing and beating around the bush by not repaying the debt?
Counsel, does your client only have the remedy under IBC? Does it not have remedy under any other law?
So apart from IBC, SURFACI could be invoked in the present matter, which
Does SURFACI still
which talks about
exist? Does SURFACI still exist today?
Yes, it does.
Please find out.
Researcher, please find out and inform your speaker about it.
Because to my knowledge, SURFACI was specifically revoked and repealed with the coming in force of the IBC. Your researcher can help better, because I seem to
It does
recall
exist.
some gazette notification of the government which talks about repealing of SURFACI. So I may be wrong. You can obviously do the find it out and let me know.
There seems to be no
Is that
notification
all?
to that
Is that
knowledge.
all for
We
your?
would
Yes, please.
one last one last rebuttal is that the respondents have stated that the 2014 remains date of default cannot be reached per se,
Counsel,
but
can't
Your
we need
your
to
your
internet,
voice is your
your
voice.
internet. We are not able to hear you, counsel.
am I audible right now?
It's still not very clear.
We can't hear you. It's coming very robotic.
Just a minute. Just a minute. Hello,
Yes, please.
am I perfectly audible?
Not perfectly, but okay. Please carry on.
Doesn't your
apologize.
counsel, doesn't your client have a remedy under civil proceedings before a civil court?
Usually in the usually when there's occurs a debt and default, that so my client did try to did try to give many opportunities to the corporate debtor by giving sufficient amount of time, but later when the debt was again defaulted, that is exactly when section 7 application was filed. And it under debt recovery tribunal as well, um, there is ways to go about this.
Okay. Anything else?
No, the council would like to sum up the rebuttals. It was a pleasure arguing before the court.
Likewise, likewise. Do we have time for sir rebuttal?
Court master,
I think we should give the respondents time for sir rebuttal.
if we have time. How much time is there, court master?
Your Lordship, the time has already been exceeded, but it's up to your discretion if you can give.
5 minutes.
I think we can give them few
5
minutes. Yeah.
5 minutes.
Respondents, please.
Yes. The petitioner, the appellant had, the speaker one had mentioned about the debt that we were not liable to repay it back. So to this, I would like to add that our client is a company that has been incorporated in the year 2013. I'm sure the bank has looked upon our credibility and only then it has sanctioned a loan of rupees 500 crores and not otherwise. So when they have considered so accountable, I'm sure that means something. And also it is the banks that have not reverted to our proposals from the year 2017 to 2020 until the COVID outbreak happened, that too in the month of February, when there was lockdown and everything was in a really problematic situation, when they expected us to repay it back, and within a month they considered us a defaulters and initiated all of this. So I'm not sure which communication lag they're referring from our part while all of it is on theirs. To the second issue that they had talked about the OTS acknowledgement, we are never denying the fact that OTS acknowledgement exists, but for the sheer fact it is not unconditional. It is conditional in nature due to its very nature. And also the loan amount that was sanctioned was of 500 crores, and the OTS settlement, I'm certain it is not of the same amount. So the interest has to be